So welcome everyone to the next session in our NIL series here at the Berkeley Center for Law and Technology. Once again, these type of programs are always dependent upon the quality of instructor that you get, and Ksenia has put together another great group for us to talk about NIL and what it really means to college athletics. So I'm going to turn it over to you, Ksenia, to do the introductions. And once again, thank you all for coming. I know this is volunteer time. You're helping families, you're helping students, trying to help them through a fairly difficult decision process and time. So again, thank you. And Ksenia, thank you again for making this all happen.
Thank you, Wayne. So today we're continuing in module 2 of our series that focuses on the intersection of immigration law and NIL. Many of you have been facing these challenges for the last couple of years since the implementation of the NCAA rules and the limited opportunities that are available to international student athletes vis-a-vis their restrictions as F1 student visa holders. So last module, we kind of focused on some basics. We talked about the basic definition of work under immigration law and what kinds of activities that would typically be involved in NIL engagements might trigger these provisions of immigration law that say, well, this is work and this needs to be employment authorized. And that's where we run into the trouble with the F1 visa, which, as we discussed under the prior module, has very few authorized scenarios for employment, none of which really work particularly well in the NIL context. So I want to continue this conversation today by really talking about sort of starting the conversation from the spectrum of risk. And I think that there's a little bit of a misunderstanding out there in the field and the industry as to how enforcement works and how immigration agencies really look at NIL activities by international student athletes. So since the rules were implemented in 2021, we've seen a number of schools try different things. We've seen collectives try different things. We've seen individual athletes try to get involved in the NIL space in a way that they perceive, whether with advice or not, to be immigration compliant. And one of the misunderstandings that I've personally observed in that context is that folks are coming out and saying, well, we did this, we made it public, no one came to us knocking on our door and deporting the athlete, therefore what we did must be fine. And so to kind of flesh this out, I've got two of my colleagues here today who are going to be offering slightly different perspectives. So Dan Berger is my law partner at Green and Spiegel. He is going to be leading our practice on higher educational institutions and hospital systems. He has a lot of experience working with universities and a ton of experience in immigration law more broadly. Chris Richardson is my colleague who is also a practicing immigration attorney, but also a former consular visa chief. And this gives us some really interesting perspective because he's going to be putting his consular hat on for us today and really talking about the risks and rewards involved from that consular perspective. So Dan, I kind of want to start with you. Can you walk us through sort of what enforcement might look like? When are the touch points with immigration agencies that might trigger somebody to look at what a student athlete is doing on his F1 and for somebody to say, maybe I don't like this?
Sure. Thanks, Ksenia. Thanks for including me in this. So there are really two ways to think about that. One would be the touch points for the individual student athlete, and the other would be the touch points for the university. So thinking about the student athlete, in general, immigration officials don't have time to follow people. So they tend to look back when somebody is applying for something new. That could be when they're applying for post-graduation work permission, when they're applying for another visa, when they're traveling and applying for a consulate, as Chris can tell you more about. They're applying for a visa stamp at a U.S. consulate abroad. They're flying into the U.S. So the touch points tend to be when they're doing something new that involves direct contact. And I think there we want to think about what the person writes down on their application if they're submitting an application, and also what is available on the internet. Immigration officers I have seen randomly Google people, and I always Google all my clients because I want to know what somebody else is going to see, and I want to help them understand how to explain that. The other piece of this would be for the institution. Institutions do have regular site visits. They have SED, they have field reps who come, and they also have recertifications that they have to do periodically for their student visa programs. So the institution would tend to be to have a touch point when they're recertifying or being inspected.
Yeah, that's really interesting. So are you in agreement with me that, if something, even if it's egregiously in violation of immigration law, if something's made public, ICE is not going to come arrest that person and, put them on a plane and send them out?
No, I mean, I think as lawyers, we're all trained to never say never. It's like the doctor saying, no, there's no way that spot could ever be a problem. But I mean, I can think in 30 years, I can think of one situation where an ICE officer saw something in a newspaper and that indicated and there was a problem, but it's very, very, very unlikely.
Yeah, and I think I would add here that ICE has limited enforcement abilities, right? They have limited resources, and they have priorities that they have identified as an agency to focus on people who are, high risk. So people who are, potentially from criminal backgrounds, people who are accused of, having connections with terrorism, national security risks, things like that. So, student athletes who are engaging in activities that may violate their F1 visa are going to be very low on that totem pole. And I think, that kind of gets us in this spectrum of risk conversation, right? Anything that we do, in my opinion, and I've said this over and over again on various webinars and presentations that I've been a part of, when you are doing NIL on an F1 visa, we're always talking about risk mitigation rather than risk elimination, because this is not a visa that's designed for these activities. There's nothing here that's a clean fit. Therefore, when we're applying things in a novel way to a classification that's really just not intended for this, wasn't, these activities were not contemplated as a part of the classifications, then we're really talking about that spectrum of risk. So on the spectrum of risk, we think that the risk of ICE coming to detain an athlete who might be in violation of his F1 status is pretty low. It's going to fall in the low end of the spectrum. And as Dan mentioned, one of the touch points that the student athlete might have with an immigration agency that could trigger some consequences is the touch point with the consular interview. And Chris, could you just explain to us, what is a consular interview and what context would that happen? And most importantly, can we talk about the powers of the consular officer in that non-immigrant visa context? Are these decisions appealable? What is the level of training that these guys are getting? How did they think about these things? And what do you think is the reception that an athlete who's trying to do NIL on an F1 visa could potentially get? And we'll get into like more specific scenarios, but if we could just kind of broadly cover this from the consular perspective.
Sure. And I think it's important to understand that visa officers are really jacks of all trades. So to take a step back, every consular officer gets assigned to a post after we've been trained and experienced as U.S. diplomats. That's what we are initially, U.S. diplomats. And after we go through the process of becoming U.S. diplomats, we're told, okay, you're going to go to X, Y, or Z post, embassy or consulate, and you're going to do visa interviews. And I think every officer goes into it thinking, oh, this won't be that hard. It'll be 1 or 2 interviews. And it ends up being that you're doing hundreds of interviews. Every type of visa applicant that's out there. You're going to be interviewing for people who want to go to Disney World. You're going to be interviewing people who are going to be students. You're going to be interviewing people going to funerals. You're going to be interviewing business people, and that's on top of doing other types of things like U.S. passports or consular reports of birth abroad. And so it's just a lot. And so, I'm an immigration attorney and a consular officer, former consular officer. And my immigration attorney friends are always shocked when I tell them that the type of training that we get, it's really just 3-4 weeks. That's it. We're basically crowded into a room. We're told, okay, this is the INA. That's what the INA says. Go out to post and figure it out. And that's what happens. And so it's important that people understand this context, because I think universities, immigration attorneys, and other people give the consular officers way too much credit. They really think these officers know so much, and they really just don't. They have just enough knowledge of the law to make them incredibly dangerous, and they are. I was one of them, I know. And so what happens is that if you're a visa officer, the things that you really care about are your numbers, because you don't want to issue too many visas. You also probably don't want to deny too many either. But in the context of NIL and the student visa, it's really critical that people understand that the officers, when they see somebody like that, they're not going to be thinking, oh, that's such a novel and creative and cool way that you're doing this. That is not going to be the first thing on their minds. The first thing that's going to be on their mind is this illegal? You were working in the US, you were on a student visa, and they know very little, the officers, but they do know that much, that you can't work on a student visa. That's what they know. So they'll say, hey, you have this NIL deal. That's pretty cool. Let me Google it and look up and read about you in the newspaper. That's great. I'm going to deny your case now because you're not supposed to be getting paid working in the United States. And not only, in terms of a renewal, could your case be denied, but they might say, well, you were working illegally for a long time here, it seems. And so that means that I'm going to give you reentry bars, or I am going to really just hurt you and not just give you the 214 general denial, but I'm going to give you ineligibilities as well. That's completely within the purview of the officers. And I've seen officers do stuff like that. And if the officer denies you and puts all this stuff on you, these ineligibilities, your recourse isn't any kind of appeal, because there is no appeal in the visa process. Your appeal is to apply again, talk to a different officer, and maybe you'll get lucky. But the thing is, we as officers, we talk to the other officer, right? And so if I've denied you, you're super famous, I've denied you because you were working on this NIL, I'm going to tell my colleague the same thing, and my colleague is not very likely to issue you the visa either. It shouldn't work that way, but that is the way it works. And so I think that is the big concern that I have around the whole NIL concept, is that it's going to be hard to convince a consular officer when you come for renewal that this is a thing, because this is all very novel. I do know that the State Department is studying it. They're looking at it. They probably need to do something about it, but they haven't. And so it's a real vulnerability on behalf of these athletes, that they might go to these consular interviews and these officers might look at it and say, oh, no, you can't be doing that. You can't be working on this. You're a student at the end of the day. And even though these students might not think of themselves as students, they're on a student visa. And so a student visa's requirement is that you do not work on it, except in certain circumstances of STEM and OPT. But ultimately, you're not supposed to work on this. And so it's very possible that a consular officer can just look at that and not look at the novelty of it, but just what the law says and what their colleagues are saying around them.
Yeah, that's super helpful. Thank you for that context. Kind of want to transition to some of the workarounds that folks have come up with, right? Because of course, where there's a closed door, people want to go around it, right? And I want to just throw out a few things here. So one of the first workarounds, I think maybe even the very first workaround in the NIL era that I can remember, was in the fall of 2021 when Oscar Tshiebwe, the superstar of the Kentucky basketball team, became the face of the NIL and immigration problem, being from Nigeria, being very famous, being very marketable, and not having the opportunity to safely do NIL in the United States. The Kentucky basketball program took him and all of the Kentucky basketball players, put them on a plane and flew them to the Caribbean and had them do content there in exchange for remuneration. Now that scenario was one of the first, and as I said, for an attempt to say, okay, we're going to try to work with these restrictions. We understand the restrictions, we're going to try to work with them, right? So they went out, they did the work outside the US. I'm not sure where the compensation happened. That wasn't publicly disclosed. But we'll start with Dan. Let's just kind of work through both scenarios and tell me if it makes a difference for you from, that immigration lawyer perspective, right? So let's say the Kentucky basketball team came to you and said, hey, Dan, we're going to fly him to the Caribbean. We're going to shoot some, NIL content there. We're going to come back. The team is going to post it on their platforms. Oscar's not going to be posting it on his. And he's going to get paid. One scenario, he gets paid back at home. Another scenario, let's say he gets paid in the US. What are you thinking as an immigration lawyer? Is that working for you?
It is working for me. I might suggest that I should go with them to the Caribbean just to supervise and make sure everything's going well. But no, but seriously, I think this has been, in the university world, this has been a workaround that's been used way before NIL was a concept. I have many faculty members who have opportunities to do consulting, to get an honorarium for reviewing a book chapter. They're on an H-1B visa. The H-1B does not allow them to work in the US outside of their university, but they go home to Ireland for a few weeks over the summer and do all their consulting work. Or then I don't see a problem with that. I just would want to make sure that the person is ready to be able to explain that they understand what they're doing so they don't misstate when they're talking to an immigration officer. Curious to see if Chris has concerns, but I would feel very comfortable with that.
The consular officers are not really good with workarounds, unfortunately. And so if you were to do something like this, you would need to literally spell out what the law is, because officers aren't, when you do a consular officer interview, you really have to think of it as like a marketing exercise and not a legal exercise. You're marketing and selling your client, right? And so I think a lot of times lawyers will have the law down, but not realize that these officers have like 3 weeks of training, right? And so they're not going to know what the law is. So if you're going to do that and you're going to go before a consular officer, you really have to write a short, concise letter, both explaining to the foreign national, but also to how do you convey that to the consular officer that, hey, this is what the law is, in a very simple way so the officer understands it. But more importantly, your client needs to be able to explain that to the officer, because consular officers are not USCIS officers. If you gave this scenario to a USCIS officer, boom, easy call. Consular officer, I'm not so sure, because I think a lot of them are still going to say, oh, this is a workaround that you're doing to get out of the fact that you're working illegally in the US, denied, 214B, right? And just because you win on the merits of the law, in the actual law, you don't win on the spirit of the law to a lot of consular officers. And I see this a lot with immigration attorneys, because they'll say, well, my client only stayed in the US for 5 months and 29 days. Right. And so, you can't deny them because they only stayed for that 5 months and that 29 days. And officers are like, no, I don't care about what the letter of the law says. I care about the spirit of the law. And so to counteract that, lawyers and students are really going to have to explain to the officer what it actually means to go to the Bahamas, why that's important, why that, and not only why is that legal, but also how that also meets with the spirit of the law as well, that they're not working in the US, they are working abroad, and they're contributing, to their students, and they're still students, and they're still scholarly. You really have to not sell it, but certainly talk about it in that way, and not talk about it in the way of it being a workaround of any kind. Because I know as a visa officer, if someone came to me and told me that story, I'd be like, I don't, as a lawyer, I'm like, oh yeah, that makes perfect sense. That's very logical. It's well within the law. But knowing my fellow former officers, I can see them wanting to know more about how this meets the spirit of the law rather than just what the actual law says.
Chris, I have a follow-up question, of course, because you're a Duke alum, right? So Oscar Tshiebwe comes to you, right? Like,
Yeah.
are you like, sort of wrestling with your internal loyalties on that one?
Oh, absolutely not. Absolutely not. If anything, if I did for any and even inkling of that, I would pass it to my fellow officer. But in fact, I'd probably be harder on him because I have a point to prove. And that's what people always have to remember is that officers have points to prove. They want to show that they're impressive. They want to be the one to deny that big case. And if you are like, well, how cool is that, right? Like, oh my God, I denied like one of the star basketball players and I'm a Tar Heel or something like that, right? And so that's why it's really, really important that you have good legal counsel and that legal counsel really trains you on or helps you kind of understand what are the risks, what are the real risks, especially with the consular interview, but also what are the best ways that I can explain it to this officer that so that they understand and they feel comfortable issuing me the visa.
Yeah, so I mean, this scenario is interesting to me because it was the first scenario that we covered in our book that Amy Maldonado and I wrote on NIL and immigration. And it was actually a surprise to me when Chris's former colleague, Mandy Fierbacher, who was a guest in our book and who gave the consular perspective, really kind of shot this down because Amy and I had the exact same reaction that Dan had. Well, immigration law is not extraterritorial, so it's not concerned with what you're doing in a different country, right? And so we felt that it was fine, and Mandy came back with, well, the spirit of the law, and for me that was a shock, right? And I'm not new to this. I've been practicing law for 17 years, but we forget that the consular officer just has a vastly different perspective. And that's where we, again, going back to our spectrum of risk, right? So the risk of somebody coming to deport your athlete, pretty low, right? But we slide well up in that spectrum, right? When we have that consular interview. And Chris, could you kind of speak to, are there differences at different posts? Do you think that, there's home court advantage? You go back to Nigeria if you're Oscar Tshiebwe versus, going to the Caribbean because it's closer. Is there a sort of a spirit difference between these consular posts?
I always tell people there aren't bad posts, they're just bad officers that go from post to post. So really officers, it doesn't really matter to them. But I would say though that if I were a Nigerian athlete, I would probably interview in Nigeria over the Caribbean or Mexico or Canada or any other country. And the reason I say that is because the officers in Nigeria probably marginally understand you to be an important person, and they might talk to the local staff about you, and they might feel a slight bit more loyalty to wanting to help you as opposed to a third country where they might not feel that same way. But I'm saying just on the margins, very, very little. Most officers, it doesn't matter what country you're in. If they're dumb in one country, they're going to be dumb in another country. If they don't know the law in one country, they're not going to know it in another country, irrespective of they're in Nigeria, the Caribbean, or wherever. Ultimately, I think that every person like that should just be prepared for having that really bad officer and expecting that this officer has no idea what the law is, has no idea what rights are there. And really, you have to be speaking again, like Mandy said, to the spirit of what the law is. So yeah, I do think there's a little bit of an advantage, but it's not a particularly strong one.
Yeah. I also think it's important to note that consular officers are not required by law to entertain any form of evidence, right? So this is where I feel like, you could really get into the weeds with going to the Caribbean because, you have a video of Oscar Tshiebwe on a Caribbean beach. How do we know that's not Florida, right? I tell my clients, if you're going to do something outside the US, I want you like in front of the Sydney Opera House, Big Ben, the Eiffel Tower, like have something in your background that makes it very, very clear if the consular officer Googles it and finds it, that it is in fact outside the US. But let's kind of get deeper into the weeds here, because we've seen, you know, all kinds of scenarios. People want to get creative, right? Everybody's so creative. Have you seen that TikTok lady? I love her. So everybody's so creative in NIL. One of the very persistent kind of themes that I've seen in NIL workarounds is this concept of passive income, right? What if I'm earning passive income, Ksenia? You know, how does that change the analysis, right? And my take on this is, you know, well, what do you mean by passive income? I think everybody has a slightly different definition of what passive income might be. I personally am not comfortable saying, you know, giving any sort of blanket statements on this is okay and this is not, because I think every NIL deal is detail specific, right? And what you may consider to be passive may not in fact be passive. But another sort of element that's driving this passive income narrative is the idea of passive income under the IRS code, right? And the sort of minimal activity threshold under the IRS code. So Dan, what are your thoughts on passive income and, you know, sort of the interplay with other areas of law that might define what passive income is and how that comes back, and whether it's binding on immigration law or not? What are you thinking here?
And I think this really goes back to your original point of mitigating risk rather than eliminating risk. You know, I think that there's a continuum in terms of passive income. You know, I think this isn't in the NIL context, but if I buy 10 shares of General Motors and just sell it a year later, that's passive as far as I'm concerned. Or if I have my money in the bank and I'm earning income, that's passive. There are two immigration court cases, and this is kind of the way lawyers work. For those of you who aren't lawyers, is that we look out at cases and we try to make our best analogies to our fact pattern based on the cases that judges have decided. So there are two old immigration cases that focus on this question. One is with somebody who owns a motel. It was an international student who owned a motel and had somebody else managing it. Really just owned it, was not spending minutes of the day cleaning the rooms, renting them, sitting at the front desk, managing them. And that was generally okay. I think that's a slippery slope, because when I read that case the first time, I remember thinking to myself, was he really not covering for his manager when the manager was sick? But anyway, that's closer to passive income, where you own something but you are not managing it or operating it. The other case that is out there has to do with a set of ice cream trucks. So there was somebody who bought a bunch of ice cream trucks and was stocking them, coordinating the drivers to go on their different routes, planning out the routes, making sure the trucks were refilled when they ran out, and so actively spending minutes in the day. And that was clearly unauthorized work. So if you try to bring that to the NIL context, I think in general, if somebody, you're closer to being in a better place if somebody is taking your picture and then they're doing something with that image, and you're in a less good place if you are actually giving a testimonial. You know, I'm sitting in Florida, not in the Bahamas, doing some kind of testimonial for Nike or whatever it is, because I'm actively spending time. I guess the only other thing I'll say is that there are I think one of the ways to look at this also is just whether it's, and we can talk about this later if you'd like, whether it's possible to try to get some kind of work authorization through the student visa for what you're doing. But otherwise, I tend to focus as much as possible by analogizing to one of those cases and thinking about whether I'm spending time versus not spending time.
Yeah, I think that analysis is spot on, and that's kind of how I do it. You know, what I want to know from reading the deal, right? And I don't trust on anyone's summary of the deal. I want to see, you know, sort of the documentation for the deal to be able to run proper analysis. But what I'm looking for is, are you being asked to do something that you are not otherwise doing, right? And if the answer to that is yes, and that you are being asked to do it while you are boots on the ground in the United States, I have a level of concern, right? And I think another important kind of flag here is the interplay with the NCAA rules, right? And I realize that there's all kinds of sort of dynamism to the NCAA rules right now, but as I understand them, and I am not an NCAA compliance specialist, so I may have it wrong, but my understanding is at this time, the way that the rules are written for NIL, a quid pro quo is required. So for the NIL deal to be valid. So the student athlete must do something in exchange for that compensation, right? And so for me, again, if you're doing anything at all that you are not otherwise doing as a part of your, regular life as a student athlete, I'm a little bit concerned. Now, again, I'm not a tax specialist, but from what I understand from the tax code does have a little bit more wiggle room, and that, de minimis activity might still be considered passive. That's not going to be the case under immigration law. And I think that gets us into like a very dangerous territory, because if somebody is only getting their advice from a CPA or from a tax attorney who says, oh no, that would be considered passive income, that analysis is not necessarily going to apply and is not going to be binding in the immigration context. So I think, I think it's important to remember that. So Chris, what are your takes as your consular officer hat goes on passive income?
I think it's an incredibly hard argument to make in the NIL context to a consular officer. I think that it'll be really difficult to convince a consular officer that anything in the NIL context is indeed passive. They're going to be like, I'm Googling this. You're getting paid for playing. And so, I think for officers, there really is like this, there's going to be a strong mental tie between this person is playing and they're getting paid for playing, not for using their name, image, or likeness, but the playing part. And so a lawyer or a student or both are really going to have to explain that I just signed this thing and the money's just rolling in just by my image, right? Like, I think that's the way you're going to have to play it, but I think it's going to be hard. I think officers are going to think that's too clever and a half, and by a half, and they're going to think you're trying to get around the fact that you're working while playing, and you're getting paid to play and not paid for your image or likeness. And then, in the officer's context, we always think of it as, let's say you develop an app while in your home country, and then you come to the US and you're just getting residuals from that. To us, that's like passive. That's like, okay, that makes sense. And really for officers, again, because they are not necessarily the most clued into the law in general, because they're not lawyers. Passive versus active is more of a I'll know it when I see it kind of attitude for them. And knowing them, and they're not gonna care about the niceties or the intricacies between the IRS rules and the immigrant. They don't care about that stuff. That's just not on their radar at all. They'll be like, oh, the IRS has rules on this. That's what they would say. But they would turn to their colleague and say, hey, is this active or passive? And I assume most of their colleagues are going to say, listen, they're getting paid to be ballers. They're getting paid to play. And that's what this is. This isn't about their image. It's not about any of that other stuff. Now, you might have some creative officers who might buy into that and be like, oh, well, or maybe like some people will. I've seen situations where people will have their account overseas, or all the entire thing is just managed overseas. All the NIL set up, everything is done through Ireland overseas. And officers look at that and they're like, oh, well, that makes a lot more sense. That's not being done in the US. So, that's okay. But I think ultimately, though, if you're going to be creative like that, you're going to have to sell it to these officers, really sell it, because they're going to not think about the image, name, or likeness issue. They're going to think more on this person is playing for being an athlete, and they're getting paid for it. And so I think that's going to always be the bigger hurdle.
Yeah, Ksenia, I'm sorry, if you don't mind, I had a couple really quick footnotes to what Chris was saying, just because you're really making me think. Number one is just for people to understand that our immigration law is hopelessly outdated. That's that's part of the problem. And so a law that was written in 1965 was really intended to try to avoid the situation where somebody gets a student visa, they come here, they're barely going to class, and they're really working under the table at a restaurant. And the law was designed to stop that. So that's why the law is written the way it is, and that's why we need new guidance, and that's coming. I guess second thing is that with F1 students, F1 is the student visa, different countries will end up with a student visa, a travel visa that is different lengths. So if I'm lucky enough, and you all can Google visa reciprocity if you want and look at how long an F1 visa is issued for. But if I'm an F1 student and my initial F1 visa that comes from a consular officer is for 5 years, then I'm not going to go in front of a consulate for 5 years unless something unusual happens at the airport. Whereas if I'm from a country where my F1 visa is 3 months or 6 months, I may be going back and getting it often. And those folks are going to have to think a lot more. And I guess the last thing I'll say is, Chris, I was thinking that sometimes it feels from our point of view as if some consular officers sometimes just don't feel comfortable with a situation. And so rely on other bases. So for example, if a consular officer just didn't like this situation, they could potentially say, well, I don't think this person has temporary intent anymore. Or they could say, I don't think this person has satisfied the F1 student visa requirement that they must have sufficient funds to be able to support themselves here in the US, and that's why they need to be doing this other stuff. So anyway, those are my footnotes to Chris's comments.
Ksenia, can I throw in one question here? I've been recently looking at some of the collective contracts, and it seems like the new version of the collective contracts are, let's say, overstuffed with 50 appearances, basically making it look like more value, more ask from the students to maybe deal with the NCAA's coming audits on are you being paid to play or are you being paid for appearances? How do those contracts end up in front of the immigration decision makers?
Well, they wouldn't necessarily unless you presented them, right? But fundamentally, when you go to a visa interview, it's you're being asked questions. So you may be asked to provide that, right? You have an NIL deal with your collective. I want to see that document. I want to see what you're doing and what you're required to do. And actually, your question is a great segue into what I wanted to raise next. And really kind of go deeper with Chris into this concept of, is it pay for play or is it for something else, right? And so we have a number of different stakeholders in this industry who may be the source of the funds that, that are ultimately being paid to the student athlete. So you might have a student athlete who is, very good looking and is getting a deal with a makeup brand, right? And all they're doing is they're just using the brand's makeup. They're not being asked to do anything else. They're using the brand's makeup and that's it. And they're getting some money. That's probably a less likely scenario direct with a brand because the brand usually wants something in the way of posts or in the way of, product demonstration or something like that. But I have seen some interesting and creative contracts out of the NIL collective space where, particularly they do a special contract with the international athletes where they'll say that the international athlete is licensing their name, image, and likeness to the collective. And in exchange for that, they're getting money. And the contract will say, you don't have to do anything else other than license your NIL. Chris, what are your thoughts on something like that?
I think that's the best of probably a bad situation, but it's probably the best that you could possibly see. I think that feels a lot better and probably goes down a lot better with consular officers than some collective, contract that's like, oh, you have to do this amount of appearances, you have to do this amount of clicks and likes, because that feels active. That feels like, okay, that's not just your likeness and the money coming at me. That feels like you gotta do things. Anything where you actually have to do something, that's when officers get queasy. That's when officers get really uncomfortable. And that's when officers feel like, okay, I don't feel comfortable with this. And I think Dan's point is a really important one, that officers, it's not necessarily about the law, it's about that level of comfort. No officer, and there's always these external factors that go into when you approve or deny a visa. You know, you have your colleagues, you know, you have the fact that, you know, if you give someone a visa, they actually have to have a second interview with CBP. And if CBP turns them around, that reflects poorly on you as the visa officer. Your manager is going to ask you, hey, every, I think if it was like a Thursday, we get what's called the turnaround reports, where we would see all of the applicants that were turned around. Our managers would give us all of those and say, hey, this person got turned around. What were you doing? This person got turned around. Look at you. Like, and no officer wants to be in that situation. And so if it's novel and it's new, man, that's the scariest thing for a visa officer, is to overcome something that's novel or new. And so in this situation, I can see an officer being like, well, it's just that your likeness is being used and nothing else is happening, and feeling a lot more comfortable with that. But if the agreement says stuff about, well, you have to do this many likes per week, and then you have to do that many appearances per week, then it feels like there's a lot more to it. That's active, and that could lead to a denial or worse.
Okay, that's a really good clarification. Are either of you concerned with where the money is paid? So let's say we have this classic, like, you don't have to do anything, we're going to license your name, image, and likeness to the collective. Dan, do you care where that money hits, U.S. bank account or foreign account?
No, I don't. It usually would not come up. That kind of documentation is not submitted, even on a green card application where, and you know, to Chris's point about these internal reports that happens, if somebody applies for a green card, we now know from talking to officers that there are various algorithms study their F1 student CVIS record and suggest to the officer certain things to talk about that are kind of funky. So, this kind of thing can come up at a green card interview, but your tax returns are not usually part of a green card application. So it's really, so I'm not worried about where the money hits.
Chris?
I think that there's probably enough officers that would care about it that you should probably care too. Only from the standpoint that I can see an officer being like, well, you're getting the money abroad, and therefore, you know, you're not being paid here in the country. And I know that makes no sense to immigration terms. It doesn't make sense to me either. But I can totally see an officer in an officer's mind or logic. I can see like the hamster wheel moving there, then being like, oh, well, you know what, you're getting the money abroad, right? So that means that that connection to the US and working in the US isn't there, right? And so that's why I mentioned earlier that, you know, I've known some people, what they'll do is they'll have everything done abroad. And the officers will feel like, well, the money's being managed abroad, all the stuff's being managed abroad. All you're doing is your image, name, and likeness is being used here in the US, and you're just having residuals collect in this foreign bank account. And so while like, as the immigration lawyer side of me is like, no, of course it doesn't matter. The consular officer side of me is like, it feels like that is the kind of argument that the officer is going to like to hear. That, you know, because think about it this way, when you're applying for that, at the end of the day, these athletes are applying for a student visa to live and work briefly in the US and go back to your home country. What better way to show that you're going to go back to your home country than to have this bank account and have something that's established in your home country that you can say, hey, look, I even have my bank account here, right? And it's really hard to transfer the money back to America if I were to stay legally or stay beyond what my point is. And so I do think that having that extra layer of protection, as crazy as it sounds, would make an officer feel a lot more comfortable about the person in general, not just in the NIL context, but also in the, because one thing that officers are scared of in the NIL context is that it's really proof positive that you have no intention of going back to your home country, right? That for a lot of officers are like, well, if you are doing this on the college level and you're already so famous and popular on the college level with NIL, you get an NIL deal, you're probably going to stay here in this country and work in this country, et cetera, et cetera, et cetera. Now, most officers are going to be like so starstruck, maybe it doesn't matter to them. But I can see some officers being like, man, that you've really established yourself in America. And that scares me. That makes me feel uncomfortable. And I'll give an example. I've had some immigration lawyers will call me and they'll say, you know, I had this client, they only stay in America for 3-4 months at a time. They go visit their house in the US and then they go back home. What's the big deal? And I'm like, well, the officers probably look at the fact that you have a house in America as evidence that you are establishing ties to America. And the answer I always get back is, but it's not illegal to have a house in the US. You're right, it's not illegal to have a house in the US. But if I'm an officer, it's not about what's illegal or legal, it's about what I'm comfortable with. And if you have like a bank account in the US, you have a house in the US, you're making contracts in the US, I'm asking myself, well, what evidence is it that you're actually ever going to come back to this home country of yours? And so having that bank account in your home country and having those ties to your home country, inevitably it'll help you in terms of the visa interview, so the officer doesn't use that as evidence that you're establishing ties in the US versus, you know, having ties back in your home country.
That's super helpful. Thank you, Chris. Another scenario that I just want to throw out at the both of you, which is something that I've also seen in the workaround world, is, okay, what if I sign away my rights to my name, image, and likeness, or, you know, I go create content abroad, and then I'm going to enter into a contract with a social media marketing company that is going to post that content. They are the ones that are going to upload it and post it on my behalf on my Instagram. Dan, thoughts?
So when you say sign away, does that mean are any dollars going into that person's pocket from anybody anyhow?
Oh yeah. No,
Yeah.
you know,
So how's that working?
let's say I created a bunch of content. I went back to, you know, the UK. I created a bunch of content in the UK, and now my collective or my brand sponsor, whoever, is going to post that content, you know, either themselves or through a social media marketing company that has access to my Instagram account, that is going to upload it to my Instagram account and post it on my behalf. And I have a contract that says, you know, I don't post my own stuff. You know, the media company posts my stuff.
Yeah, I think this, you know, again, this goes to the question of, can I make a good legal argument versus do I really want to have to explain this to somebody? And the analogy I try to go to is what we know. Like for years, we've had these kind of situations where somebody paints a picture, and then that picture gets that they're paid to paint the picture in England. They bring the picture here, and then it gets sold, or they write a novel and then there are royalties later, or they submit an article. So I think there are analogous situations that we've argued before. I think I would, you know, in the spirit of everything Chris has been saying, I would try very hard to avoid having to have that conversation at all. But I do think there's a legal argument that there is something there, because the work was done abroad, you were paid abroad, you're done. They're making the money from it.
Yeah, and I think this really highlights that, you know, that tension that we've been talking about all along, is there really is a difference between what is permissible by the black letter of the law and what the consular officer is thinking. And even as experienced immigration attorneys, we have a really hard time shifting our gears and really thinking about it from that consular perspective, from the what could go wrong, how's the consular officer going to perceive the spirit of this transaction. And I think this is a great opportunity to kind of plug Chris's business. So Chris is the founder of Argo Visas, which is a very valuable consultancy that I personally use, and I think can be very useful to people who are considering going for, you know, an F1 renewal or an initial F1 application, and they've kind of dabbled in the NIL space and have had touch points with any of these NIL workarounds. And you know, I'll let Chris kind of, you know, correct me if I'm wrong and spin it a little bit from his own perspective. But this is a consultancy comprised of former visa officers with whom you can schedule a consultation, and you can say, okay, this is what I've done, and I'm about to go to my F1 visa interview in, you know, in Paris. what do I need to know? How do I sell this? How do I market myself to the consular officer so that whatever it is that I'm doing kind of passes muster with them? Chris, can you speak to that just for a couple of minutes, please?
Yeah, so when I was an officer in Nigeria, I was always just stunned by the amount of bad information that were given to visa applicants, and how a lot of them would be applying for O's or F1s or even immigrant visas, and just the things that they would say. I'm like, man, please don't say that. Please stop talking. That I really understand. It made me understand, though, that fortunately or unfortunately, consular officers have a monopoly on a lot of the information that we know, and we don't have an obligation, and nor do we share like why people actually get denials. And so I really wanted to close that knowledge gap between what officers know versus what the general public knows. And so that's why I created this company, Argo, former visa officers, to really help people understand what really goes on behind the window of those visa interviews, and to make sure both attorneys and clients are just educated on, if you come to the officer with X scenario, this is how the officers are probably going to react. And it's interesting, you had mentioned that you've done this with Mandy, who's a former visa officer, a friend of mine, and how her and I both came to the same conclusion without even talking to one another about this, right? Like we both said, oh man, that feels kind of fishy, because all visa officers, even though we're different on margins, we all kind of probably come to the same kind of conclusions about stuff because it just feels a certain way among officers. Now, some officers are braver than others, but the State Department doesn't encourage us to be brave about this stuff. It really encourages us to kind of follow a certain line and follow a certain path on things. And so, yeah, that's why that visa interview is really, really important. Documents and papers, that stuff's nice, but officers don't even have to look at that stuff or read that stuff. What they really care about is, when I interview and talk to you, does it feel comfortable? Does it feel like something that I can issue without fear that you're going to get turned around or do something illegal in the US?
Awesome, thank you. And we've got about 90 seconds left, so I just want to give some final thought opportunities to Dan and Chris. And Dan, we'll start with you. What is your sort of nutshell advice to folks that are trying to navigate the workaround landscape while on the F1 visa?
I guess two things. One is try to work with your foreign student advisor to see if there is a way to use the existing rules. F1 students can work on campus. They can work. So if we just admit that it might be considered work, the F1 students can work on campus. There is something called CPT. There's something called OPT. If you can try to work with that, that's all the better. So.
Great. And I think we're going to have another module that we're going to take a deeper dive into those options. Chris, what about you?
I would say that if you are going to a visa interview, that interview matters. Don't let anybody tell you, oh, I'm going to write everything down on a piece of paper, because there's no guarantee that officer is going to look at that paper. Officers have hundreds of interviews that they're doing in a day. You are just one of hundreds of things that they have to do that day. And so really, how you present yourself, how you show confidence in what you're saying, and how you convey this message is far more important than anything a lawyer is going to write for you on a piece of paper. And so, and also, just because you're famous or just because this is novel, don't assume that the officers are going to appreciate that or respect that or give you a pass on something, because for most officers, the law is ultimately the law. And they want to hear you explain it to them why you should get this visa at the end of the day.
Awesome, thank you. And my closing thoughts on this issue are generally always the same, and that is, remember, it's a spectrum of risk, and we are talking about risk mitigation rather than risk elimination. Any kind of workaround on an F1 visa will involve some level of risk, and we want to make sure that we're cognizant of that and address that risk appropriately. And that's it that I have for today. On to Wayne.
Thank you all. Wonderful, if not frightening, but great information for everyone that's going to be listening. So thank you again.
Thank you so much.